FM. Kite Radio.
Chop. And here goes, I represent for 99.1 Kite Radio, the radio with a difference.
It is 19 hours 30 all across Guyana, and it is time to enter room 592 with Dr. Yog Mahadeo and senior journalist of Kite News, Leonard Gildarie. Before we continue with the program, remember you can catch us live on Facebook at Kite Radio and subscribe to our YouTube channel to keep up to date. That is also at Kite Radio, and you can stream us live at www.kitenewsonline.com/radio/. And now, as usual, at the helm of the program, Dr. Yog Mahadeo and Leonard Gildarie. Good evening, gentlemen.
Good evening.
Good evening. Good evening to you. Good evening to you, my co-host, Mr. Leonard Gildarie. How are you tonight, sir? You look like you're wearing some racing jacket there, man. Are you off to the races? It's 109, 108 days.
Well, you know, I was anticipating this question since this midday during the elections watch. I'm a little surprised that you're hours late. I'm very proud of my shirt, this one. And two, it goes to show that you're very privileged. You're at home and you could be able to change your jacket. We at work, you know. Yog.
My dear friend, I've been at work all day behind the same thing too. But ladies and gentlemen from all across Guyana, the Caribbean, and wherever you're joining us from, welcome to Room 592, where we unleash the truth. Ladies and gentlemen, tonight we expect to have attorney at law, Mr. Sanjeev Datadin, joining us in room 592 tonight. He's going to be in the hot seat as we ask him and we grill him about all that's happened in court today and all that he thinks will happen over the next couple of days. But I must tell you, I will ask you the question that I've seen popping up on social media and all over the place, Leonard. Is GCOM to embark on a credibility exercise? Must GCOM be used to determine the issues of validity and credibility? If GCOM is to determine validity and credibility, then where will an election petition go? If GCOM can use this current appellant's case to test validity of an election, then does it leave any door for an election petition thereafter? That, in summation, ladies and gentlemen, is what Justice Claudette Singh, Madam Chairman, has said this afternoon in asking the Court of Appeal to throw out that case that is blocking the declaration of results. And yes, I must be smiling because I like to see language like this, Leonard.
Well, absolutely. When GCOM's son wakes up in the middle of the afternoon, in the middle of the week or the end of the week, and decides that it knows that it has some rights, it has some privilege, it has powers, and it has independence, that is something that is very, very important towards our country.
Correct. And ladies and gentlemen, I want to remind you, everyone, let me remind you that if the court, this is so correct, Leonard, if the court has to assess validity of votes, if the court has to assess the credibility or all of those questions, whether there was manipulation now or not, then there is no space for an elections petition. It means you are dealing with an elections petition now, and you have removed the court from its ability to listen to an elections petition. So this release that we have seen, Leonard, that has the chairman of GCOM telling the Court of Appeal to throw out that case that is blocking the declaration of results. The Iron Lady has spoken. And with the Iron Lady has spoken, I'm sure that Mr. Sanjeev Datadin might have had to appear at some stage. I don't know if he did as a student, just listening, or if he appeared as an attorney at law, but he would have seen the Iron Lady at work. Mr. Datadin, welcome to our Room 592 tonight, sir.
Good afternoon, you. Good afternoon, Leonard. Good afternoon to all your viewers and listeners. Good afternoon to my beautiful wife. Let me start, Yog, by telling you on the last occasion when you invited me and I agreed to be on your program, and I couldn't make it for reasons, personal reasons that related to my little boy, who might not have been sleeping as well because he's teething. So on that occasion, forgive me for that. So I am making it up.
But for the record, counsel, for the record, counsel, we will still allow you to make up for that one. This doesn't make up for that.
All right, that's okay. Yog, I have indeed, when I first just came into practice, Justice Claudette Singh was still in the High Court. I came in the last millennium, I came into practice. And she was known to be a very firm judge. She was known to be a judge that was unusually, for judges of, at least in my time, in my experience of that time, she was always very willing and always very helpful to the young attorneys. I was one of those that benefited greatly from her advice, if you want to say, and she would guide you. And I know a lot of my colleagues who just came. Mm-hmm. She was always willing to talk to you, to say to you, you know, this is the way to do it. This is not the way to do it. This is how you address the court. This is how she's always been that way. And I've known her since then to be that same person.
Correct.
I mean, the difference has been, of course, on the national stage and in the politics and then the things that go on. It might be a different environment. So
right. Well, Leonard, let's put it this way, that ladies and gentlemen, our viewers and listeners, I want to remind you that throughout this long 100-odd days, we have all been frustrated. There's been so much ups and downs that it's been a really terrible nightmare all of these times. But through this process too, we have learned. Guyana has learned some serious lessons as to who stands on the side of Guyana versus who stands on the side of political opportunism. Today and after this election saga would be over, we would know for sure the men and women that are just purely political opportunists in it for the politics. I wouldn't say the money at this stage, but in it for their own gain, whether it's power or something else. And these days, these 100-odd days, Leonard, would have certainly separated these people. And we have seen, and we are seeing now, religious organizations stepping to the fore. We are seeing civil society stepping up and calling. I want to just put this also in perspective, ladies and gentlemen. Whether they're court cases or not, in any other country of the world, the losing candidate would have conceded. Mr. Granger had those SOPs since the night of March 2nd, 2020. Mr. Granger chose not to look at the SOPs, and that's his choice. But him not looking at the SOPs does not change the truth. And it does not change that those SOPs show that they have lost these elections since March 2nd. Mr. Granger ought to wake up from his slumber and realize that he has put this country through more than a year of problems. I have said today on Radio, Leonard, and I wish to repeat, all the while we were thinking, yes, Mr. Granger will get it right and he will do the right thing. Not to be. And finally, Sanjeev, I'm going to come to you with the legal side after saying this, that ladies and gentlemen, it is the same Mr. Granger that after everything, he was one that invited CARICOM and said they're the only legitimate interlocutor. He is the one that restricted international observation of these recount to just 3 persons. He is the one that came out publicly and said he's not going to allow CARICOM Center to come. So, ladies and gentlemen, he also said, oh, Guyanese, you must wait on these 4-step processes to be completed. Well, guess what, ladies and gentlemen? He didn't wait. His party didn't wait. And just to remind you, when he called for the recount, his party went and tried to stop the recount in court. Remember that, you little more case? When they know, yes, go on.
And Yog, it's even more thing when you look at it, without getting into the details of the proceedings in the court. Today was odd. I know that I understand it was myself and other attorneys who appeared. We all appeared via Zoom. So, but I understand it was broadcast live on Kaiser Radio and other stations. So everyone could have followed it. I also heard that the audio might not have been so great. But the position was this, and the position is this. Everyone would have heard at these proceedings, all of the political parties had a representative, and one by one, their attorneys asked that they be joined and identified in whose name they would be joined as the representative of the party. That took up quite some time. I mean, Senior Counsel Douglas Mendez, who was leading me, and the other attorneys, Mr. Nandlal and Mr. Kisoon, he asked for the 2 persons to be the representatives of the PPPC. Mr. Ramkaran asked for the persons to do with the joint list with the 3 parties of ANOG, the New Movement, and Liberty Justice Party. We had Mr. Kashir Khan ask it. Interestingly enough, although the proceedings were served on APNU AFC, no one appeared for them. No attorney came to court for them either, which leads me to believe that they have no concern about being there. I mean, they're the applicant. And the attorneys who are on record for the applicant are in the past proceedings, the attorneys who have in the past appeared for APNU and or AFC. So I rather suspect that that's why they weren't there. Mm-hmm. Or that's why they did not need APNU to be represented. And that's not very fair, and that's not what Granger has been saying repeatedly, that he will obey whatever GCOM says. He will abide by the outcome of GCOM. And I think GCOM has gone through the gamut. They have gone with the recount. We still, GCOM wanted to have more counting stations. The COVID task force that is made up almost entirely of government operatives said they couldn't do it. They actually went ahead and added the 2 more stations and then got the approval subsequently. These are not things that are very, that Guyana would be very proud of to look back on. These are not things that our leaders should ever be engaged in and our leaders should ever do. But now we're at these proceedings, and these proceedings are a little unique. They fall under a very unique process, meaning what it is the court is being asked is to interpret a part of the Constitution. So this is restricted only to an interpretation. This is, in this process, I believe it's common ground, although these proceedings were filed. One of the things that stood out to me, and I saw that it has been mentioned in Gaichur newspapers as well, and it was indeed mentioned in Stabroek News, that in the Hollandar case, an order was made that, as it related to Mingo and the numbers that he wanted to, his fantasy numbers should not be taken into account, etc. But the chief executive officer, he went ahead and prepared his report. And in the Ulita Moore case, he swore an affidavit that said that he had prepared the report and they were ready to go ahead, notwithstanding the fact that a recount was being discussed by the two leaders, and notwithstanding the fact that they had said they would do a recount. That's one thing of it. The other thing that happened, the other process is while that was going on, an order had been made, an interim order had been made. But now we have a situation where the proceedings had not even been served. I guess word was around that legal proceedings had been filed, and the chief executive officer was to have done something by a specific time, which is to do his report by 1 o'clock. But in the face of pending proceedings where no orders had been made, it had not seen the eyes of a judge yet, it had not engaged the court, Mr. Lowenfield decided not to do anything because of the existing legal proceedings. You see, these are the things that we cannot in Guyana accept from public officials. And these are unfortunate things. They are very unfortunate that this is the situation that we're in. You know, but what should happen? We have to move forward. These proceedings, there could be no injunction to stop anything GCOM acting. There could be no injunction to stop anybody from doing anything. These proceedings are to interpret the Constitution. And the argument which have been submitted and the arguments which are going to be considered by the court is whether the court has any jurisdiction to do this at all, because I think everybody's been reading the Constitution, and all the newspapers and the news services have been considering what it means. And on the face of it, it really relates to the election of a president, and the qualification of the election of a president, and an interpretation of the Constitution. But there seems to be a condition precedent that you must have actually been elected the president, and all of that must have been completed, which is the declaration, the swearing, etc. And I see in the news just before I came on, and I believe you were mentioning that as I was logging in, I heard the end of it, that Newsroom was carrying a story, and is carrying a story based on the submission of the chairwoman of Claudette, Justice Claudette.
Sanjeev, let's come.
They were carrying a story saying she was saying that it doesn't come up, it doesn't arise yet. And those are the submissions. I've seen her submissions, and that's what she's saying.
Good. Let's come to that in a second. So, ladies and gentlemen, I just want to remind you that knowing the background is very important, and knowing the players are very important. Leonard, you will recall that last night in room 590.
Yog, could I interject here? Could I interject?
One second.
It is important. It is important. We have a breaking story that is now coming out, and I think we could look into it right away. The Justice for All Party.
Yes, that is what I was going to say, my brother.
Okay, and then there's a development.
I was going to preface it.
There's a development. Well, you were going to go ahead because he has made some serious statements there.
Correct.
And I'm going to give it over to you, my host. But also there's a development that we're following with the Alliance for Change, which is a major part of our major faction within the coalition. So I would want to hand the floor over to you with regards, first of all, to the Justice for All Party, the statement here, and then, of course, to the Alliance for Change. Go ahead, Yog.
So, ladies and gentlemen, recall that last night in room 592, we made a public call to the Justice for All Party, to the WPA, to all of the parties in the coalition, that it is now time to speak up, speak out, because it's either you are silently, if you are silent, it means you are backing what's going on. So you need to speak out. We are happy to tell you that we just got to, a couple minutes ago, we got word that the Justice for All Party has conceded that they have lost these elections, and has said clearly the following, that the recount has shown that the PPPC has won the elections, and therefore Mr. Irfan Ali should be allowed to be sworn in without delay. And so this is good news. Leonard, I'm sorry I had to pull it away from you.
No, no,
remember
please.
our call last night.
Yes.
And I know that the newspapers are going to carry some more releases tomorrow, ladies and gentlemen. It is important we remember these things. Religious groupings are now speaking out and calling on Mr. Granger to concede. As I said to you just now, Justice for All Party has said, we have lost these elections and APNU, AFC, the coalition, must stop behaving like it won. Stop delaying. So that is the late breaking news. And the other breaking news we got, I'm going to hand you over to Leonard for that, because it would appear that Kaito News carried a newscast today, a headline today, that one of the ministers has packed up and moved out. It seems like even the president would have packed up and was ready to move out of State House. And today also Leonard has some more news that another minister seemed to have had a farewell. Leonard, you want to take that one?
I think there's some development. There's a development story that Kaito News is following, and that is Comrade Ramzatan might have. We are hearing that he met with his department heads, and he seems to be preparing to concede as well. We don't know as yet. As of now, it is a development story, so we are waiting on that. But right now, there's a statement that is coming from C.N. Sharma for the Justice for All Party. You recall that his son, Jaipal Sharma, was a minister within within the coalition. And so he was a candidate. He would have shifted to become a candidate in the coalition. But now you have a coalition partner is basically saying that we concede. As far as we're concerned, the People's Progressive Party has won the elections. Let us get on with it. This is a democracy. It's a very serious statement.
Sanjeev, if coalition partners are falling out, what happens to the coalition that contested these elections?
Well, that poses essentially what will happen is that there was a list, and they would have gotten names, and they would have been putting people on that situation. Mm-hmm. It would essentially mean that the coalition has broken up. Whether what will go forward now will be the one group will go ahead and simply say that this is what will happen is yet to be seen. But it would seem to me, I have been hearing since this afternoon, I have been hearing that Mr. Ramjatan has informed his staff that hierarchy of the AFC. Mm-hmm. So I've seen reports online, I've seen comments about this online, so this might indeed be the position. I have seen also, well, we know that ANOG, Liberty Justice Party, the new movement, a lot of those parties, since at the time of the counting at the Artichoke Convention Center, have all conceded that the PPP have won. But this time, I believe the concession that the PPP has won and that it should be relinquished is now coming from the members of the coalition and integral members of the coalition too.
So, but on a technicality, given that these elections have not been declared, let us just say, for example, let me just say a hypothetical case. If Good and Green Guyana, I don't think that one contested these elections, but if Good and Green Guyana contested these elections and were going to get 2 seats in Parliament, and God forbid something happened before declaration and Good and Green Guyana doesn't exist anymore, what happens?
Well, essentially,
you put the man on
somebody will have to account for them. There is no other thing that could be done. Somebody will have to account.
Okay. So in this case, it can be assumed that the whatever Justice for All Party would have been due would be rolled up into the remaining members of the coalition.
Well, that wouldn't. It would depend on the agreement they have. I don't believe they can just simply proceed as if nothing happened. They're going to have problems. They're going to have problems if the AFC, Justice for All Party, are saying that these things have come to an end. Then the problem with the coalition falling apart is then it will come down to whoever is the person that is the leader of the list. I understand their arrangement was. I'm not sure if it holds to that. But their arrangement was their leader of the list, their presidential candidate, was not going to be the person to extract the names from the list. I believe that was Harold Lutchman. He might find himself in a position where he doesn't have enough people to extract from the list if they're going on their own. But remember, they could be extracted from the list and go into Parliament in opposition. I mean, that is what it appears that they should be, and that's what the results from GCOM indicate they should do. So this concession might put the problem a little bit greater, because how are they going to form a cabinet and govern if one side of the coalition is saying they've lost the election?
And ladies and gentlemen, I want to just say this to the public once again. All those decent persons from within all of the parties of the coalition, please have some saving grace, and please save your party. There are very, very decent people within all of these political parties. Ladies and gentlemen of these political parties, if you remain quiet in the face of such travesty, it means you are a quiet contributor. If you say, and for those religious groupings, I'm sorry, but if you say you don't want to speak out on politics, your silence is loud enough speech. We all need to speak out when our constitution, it has gone on for too long, and we all need to speak out. We all need this. Guyana belongs to every single one of us, not one group, everyone. And we all need to speak out and ensure that our sovereignty as a people, as a country, is safeguarded. These opportunistic tendencies must not be allowed. So I want to come back to, based on what we are seeing, Sanjeev, with regards to what the chairman would have said in her submissions to the court. The chairman has basically asked what you, Sanjeev, Datadin, what Kamal said last night, what you lawyers have been saying, that you cannot have an election petition before a declaration. And that's what the chairman is pointing out, that if you want me to be the court, it means what's the effect of an elections petition later?
Well, you see, what is very clear about what she's saying is this. You want to have a declaration or an interpretation of a part of the Constitution, which is all well and good. You can do that. But all you can obtain is a declaration. And the only remedy that they've sought that could be entertained by the Constitution is they could, the part that says about most votes. Now, if they want to interject into that anything about valid votes or anything such, which you can't do. Courts can't put words into statutes and constitutions that the drafters did not put there. But if you got an interpretation, you can't bind anybody by making findings and saying that Lowenfield could do this or Justice Singh could do this or whatever. That's not how it works. The court put a procedure in place, a very clear procedure under Article 163. If you are not happy about the votes, or if you're disputing that what are the valid votes cast for a candidate, then you must file. The exclusive jurisdiction to decide that is in the High Court. And it says that Parliament must pass laws. Parliament must pass laws so that whoever wants to enforce that constitutional right can do it. There was the National Assembly Validity of Elections Act that has been passed. That act prescribes that you should file an election petition within 7 days of the declaration. You must serve it on all the parties. And the regulations in that section provide what is the burden and standard of proof and what are the issues that have to be addressed. and how you have to prove your case. So there's a very complete regime in the statutes, from the Constitution to an act to regulations, of exactly how you, if you disputing how many votes have been cast or what votes are valid or what votes are anything, then you can do that. But you see, the misnomer that is being promoted, Yog, is very simple. What is being said and what Lowenfield put in his report is he made a determination, and he's trying to make a determination about valid votes. Well, guess what? Nobody said anything to him about what votes were valid or not. There were two places that happened. There was, while it was being counted, the returning officers, the supervisors, it was raised to them. They made a determination that they will count the votes. It was made in letters that were written to Justice Singh. How did he come about it? Now, if you look at for all 10 regions, the declarations say that these are the valid votes. Now, he is in charge of all of that staff, but that staff is doing business of GCOM.
Right.
He can't take it upon himself to sit on appeal of what they have done. He cannot take it upon himself to go and revisit it. Because what is he revisiting it on? On the basis of the elections of a complaint being made? How did he know that the complaint was genuine or not? And you know how preposterous this is? I don't know if he really looked at the numbers. So guess what happened? He decided that if there was a complaint about a ballot box, that if you complained about one error in that ballot box, and there were 300 people that voted there, he said one bad apple spoils it all. It's tainted. Strike all out. So he came up, very similar to APNU, with some figures that show that APNU AFC coalition would have won 2/3 of the parliament. Do you know how he arrived at that? He took the two sides of the figures, right? And this is not funny. When I realized it, I still haven't stopped laughing. Mr. Nadlal and I were talking about it, and he's not stopped laughing either. Do you know what happened? He did the two sides of the tabulation. He then came to a number of votes that were not or should not be accepted, and the numbers that of tainted ballots. So, and do you know what he did? He subtracted all from the PPP. None of them he subtracted from APNU, from ANMOG, from anybody. He just subtracted all from the PPP.
Right.
So he's assuming that all these complaints, which have no merit, no proof, that are made by APNU about dead and migrated people, they all voted for the PPP. I mean, if you look at the numbers, you look at his report. He has taken the two declared numbers. He has totaled up the tabulated numbers for the 10 regions. He's then found fault with a number of them because they don't have the box has some defect, as he puts it, and he's therefore discarded everything in that box. And when he's come to the number, he's deducted it from the PPP. Only the PPP.
Correct.
No other party.
Well,
That's preposterous. When you actually look at it, how did he decide to take it all from the PPP only? And if that were the case, APNU won the elections with a 2/3 majority seat in Parliament. I mean, what?
That's the thing, yeah.
What
That's
none?
the thing.
But 2/3, as you and I discussed before, 2/3 is dangerous. It means they can amend the Constitution.
Of course. And you could once again get a president for life. I'm kidding.
No, this is a 2/3 majority is a Burnham-esque thing.
Correct.
This is a hark back to the days of Burnham. He took control in that manner. Now, even so, we have to realize, and it is important that people recognize, they got to really see the wood from the trees. You have got to recognize that what has happened.
Yes.
The recount of the ballots was done in an open and transparent manner with everybody there. And everyone there, if you were at the Artichoke Convention Center, I know the CARICOM report says that they witnessed 18% of the count. But they meant 18% of the completed process.
Correct.
And we should not underestimate what those three people did. Because anybody who was there would have seen they were very careful to stay out of any controversy, very careful to stay out of everybody's way, and they did their job. And this is what was happening. There were 12 stations counting. And there was the tabulation going on in the middle, in the big area of the Artichoke Convention Center. So you know what those three people were doing? They were going from station to station to station to station, but one had to be stationed permanently in the tabulation room, and the other two would move. And that is why in all they only said they witnessed 18% completed. But they were present going from room to room. Every time there was a controversy or a query, one of them would quietly come into the room and observe what is going on, make a note, and move on.
Correct.
And they were moving. And because they were mobile, they actually would have witnessed all of the goings on in the Artichoke Convention Center. They might not have sat and actually gone through every box, but that was not necessary for what they were doing. And it was physically impossible for three people to sit there while there were 12 stations in a tabulation room. But they did an exceptional job of working from morning to night every day. And then they have made that into an issue. But you see, it is clear that nothing will satisfy what they have done. Unfortunately, what APNU has done is they have used their keyboard warriors, their paper journalists, what they have done, and they have continued to spout these negative things, and they have misled their supporters.
Correct.
Ranger has disgraced the office of the presidency. He has disgraced what a leader should have been. And he is lying to his supporters. He is lying to his supporters chapter and verse, stage by stage.
That's right.
And then he is approbating and reprobating. He is blowing hot and blowing cold. He's coming up with all kinds of things. He's 1 minute his former ministers, his attorney general, they're saying one thing in the public domain, and he comes the next day and wipes it all away.
That's right.
This is what has been consistent about the approach has been its inconsistency. It has been consistently chaos.
Right. That's right.
The only thing consistent has been chaos. And it is regrettable that a leader will take his faithful followers down such a path, because he has lied to them. The leadership has lied to them so much and in such detail that they are believing that these things they're saying is true. But it is a fact, that they have produced no evidence of a dead person voting.
That is so true, and we have continuously called that here. Yeah, it's all allegations.
Certificates, and they have put them all over Facebook about these death certificates, but they have not been able to establish that any of the persons for whom they have a death certificate and that person's name is on the voters list, that person is alleged to have voted.
Correct.
Now we have what is referred to, it's a pink sheet which is referred to as the tick list.
But Sanjeev, just before we get to that, just before we get to that, ladies and gentlemen, I just want to ensure that we all keep tabs of what is happening, because a lot of emotions would have been stirred during these elections. And to Mr. Datadin's point that he just said, we all have to realize that the politicians have stirred all of our emotions. But it's okay to have your emotions stirred and stand for truth and stand to have a country that you can hand your children to. But it is not okay to have your emotions stirred and to stand up for backwardness and to stand up for things that are blatantly and patently untrue. And ladies and gentlemen, I want to pause once again. Let me say thank you, Mr. C.N. Sharma. I thank you. You have risen up way above all the other coalition members, Mr. C.N. Sharma, and I'm proud of you. Thank you, sir. Today you have made me very proud. And ladies and gentlemen, I just want to share this with you because I see Andre and a few people have asked. I want to share this, Leonard, if I may. I know I'm reading out from your book here too. You're the journalist, but you know your brother Yog is older than you, so I have the right of being a bully.
Go ahead, old man.
Ladies and gentlemen, here is a press release that came from, let me see, the organization is the Center for Interreligious Dialogue. The Center for Interreligious Dialogue. And it reads as follows. It starts as follows. Let he who believes in God and the last day either speak good or be silent. Prophet Muhammad, peace be upon him. The release then went on to outline that from March 2nd what happened. And the last paragraphs of this release reads as follows. Corinthians reminds us that we must take pains to do what is right, not only in the eyes of the Lord, but also in the eyes of man. And Hindus worship Lord Vishnu as Satyanarayana, the Lord of truth. And our Hindu scriptures tell us to embrace dharma, which is ethics, honesty, and integrity. And it is in this regard that we, the members of the Center for Interreligious Dialogue of Guyana, call upon President David Granger to concede these elections with grace and dignity. The press release final paragraph says, our religions teach us to uphold truth and to disavow falsehood. So it was said, and so it shall be. And ladies and gentlemen, this press release would have been sent out to the various press groupings in Guyana, the press bodies in Guyana, and would have been signed by Imam Roy, Imam Faoud, Sister Shama, and other persons from within the Hindu, Christian, and Muslim organization. So indeed, the religious community has also stepped forward now, Leonard.
They wake up.
The Lord has spoken.
You see, the thing is, Leonard, and you have to realize, speaking up for anybody who's doing it. I know Leonard might be the most familiar of the three of us about it, but when you speak up or speak out on any issue, whether, in my case, whether it's a public issue representing my client or anything like that, you are going to invoke the ire of people who want to say you're wrong. And you're going to invoke a whole lot of negativity, a lot of name calling. My colleague and my friend, proud to say my friend, we went to school, Mr. Jonas. Today I see one of these paper journalists, pretend lawyers in the United States, who spouts all kinds of things. And he was the gentleman who had a friend who is a congressman who will fed him about what he should say about interference in Guyana's affairs by foreign ambassadors, etc. The diplomatic corps spoke up. And he's speaking about that. And that person today called Mr. Jonas a house slave. And
Wow.
I want to know if his congressman friend is going to have the same reaction to him when he is nothing but a petty racist. And if you look at what has been going on in the past few days, you see, during the recount, when all of these things are being raised, it was a running battle. Every day there would be lies, and every day persons would put it to. I was one of those persons who would explain what was going on and explain why it is that this is not true. Other persons were doing it, and they were doing it in the press, on social media. It was a lot to get done. And when all of that was debunked, everything which happened, the number of migrant voters, the number of dead people, it was all debunked. There is no proof. They're saying it. And they're making it out to be this grand conspiracy of the whole planet. And they will use all these things about whether there was the lobbyist firm Mercury. They would raise every red herring, and everyone would realize that these are things that people saw for themselves. These are things that people heard and saw for themselves in Guyana for the first time. And that's why they knew that something was wrong. That's why they knew that Mingo was cheating. That's why they knew that Mingo committed fraud. But now you go and because Mr. Jonas Timothy is a leader of a party, well, he's chairman, because he's doing that, you call him these names, these racist names. And you notice that what has started to happen is because those persons are using these racist names and comments to describe persons who are leaders in Guyana, you notice that everybody now takes it as a free-for-all in the past few days to make all these racist comments. I mean, there have been regrettable instances where people are doing it, but it is now down to everything that was said has been debunked. Every argument that you've come up with, they have lost. Every court case that they have filed, they have lost.
So I want to take you, Counsel, if I may, if I want to take you quickly down some other roads. Tomorrow, that case, there is going to be oral arguments or presentations from 11, half an hour. I think the court has made it clear that it is acknowledging the time constraints here, and it wants to get this thing over with and done. So I want you to tell us if you believe there is a role for CCJ in this entire thing. We've seen some arguments in that direction. And I want to ask you if the door is open for that.
Now, the thing is this. The provision relates to, very clearly, interpretation of the Constitution, which means you can't issue any coercive orders. You can't issue declarations. You can't issue restraining orders. You can't issue declaratory orders, injunctions. None of those can be done. You can say that these words mean this. However, if the court goes beyond anything other than interpret the Constitution, then, of course, an appeal will lie to the Caribbean Court of Justice. If the court does not do that and stays within its confines and remit of its jurisdiction, then there is no appeal possible to the Caribbean Court of Justice. Essentially, in legal terms, it means whether it is intra-vires or ultra-vires, whether the court exceeds its jurisdiction or its remit in the Constitution, or whether the court properly exercises its remit under the Constitution. So that's what it would become to. But you see, if you understand a little bit of how, and let me do my best to try to explain. This provision is very unusual, and I'm sure everyone is realizing that it's an unusual provision, because the Court of Appeal is being engaged without the High Court being engaged. So that you've gone straight to the Court of Appeal. Usually you go to the High Court, the full court, the Court of Appeal, or the High Court to the Court of Appeal. There are procedures that would go. So there is never usually that you start a matter in the full court, in the Court of Appeal. There's never usually that. but for the very limited purposes of interpreting the Constitution. So now, if they say that the words they want to interpret, which we don't believe need any interpretation anyway, it is most votes cast. I mean, most votes cast means most votes cast. You don't understand that. I'm not surprised you didn't understand that 33 was a majority of 65. I mean, it is that simple. But we're at the stage where you want to interpret most vote cast. Let us say that the court were to determine that what most votes cast mean is Leonard Gildarie. Just for argument's sake, it means Leonard Gildarie. Then what you have to do, if you believe there is a problem with the votes cast, is you have to file your elections petition after there is a president, and you have to then tell the High Court judge when you're doing your petition, Judge, when you are going to interpret what the Constitution says, most vote cast, the Court of Appeal has determined this issue and you are bound by it, it means Leonard Gildarie. And that means the High Court, during the hearing of that petition, can do nothing else when they see the words most votes cast except Leonard Gildarie, whatever that is. I know that the example makes it look absurd, but it is that absurd. But that is why you don't have any coercive powers. You can't direct, you can't restrain, you can't injunct, you can't mandate, you can't do anything else. Because the parties who are involved, if you want to do that, you have to go start it in the High Court. You have to put your jurisdiction, your facts, you got to put your witnesses, you got to put your evidence in. The other side of the coin to it is the court may not have any jurisdiction at all. And that's one of the issues that are being raised by the two sides. They don't have any jurisdiction for two reasons. One is it speaks of a situation where someone has been already elected president. And the second thing is, I know everybody's been reading 177.4. If you read a little bit more than 177.4, I believe it's 5 or 6, it makes reference to the fact that the court, parliament, is supposed to pass some legislation to direct how you would approach the court in 177.4. And that has never been done. And there are many decisions in the Caribbean, especially from Trinidad, where Chief Justice de la Bastide has made some rulings, and he says, if that's what the Constitution says, that Parliament has to make this ruling, and they're not doing it, not make this ruling, make this act or make this procedure as to how you will approach a court, and they didn't do it, then there's no right to approach a court because there's no procedure set in motion. Parliament decided in its wisdom, we would say, in its infinite wisdom, not to do the procedure, which means they don't want you to be able to do that. Now, some people are saying that what that means is, it's in the Constitution and therefore you lose the right. No, you don't lose the right. What you lose is this peculiar way of bringing the right up, which is in the Court of Appeal in the first instance. What you have to do now is you can't do it in the Court of Appeal because there is no enabling legislation for you to do it. You have to file it in the High Court. You have to start in the High Court. And all that means is that little power that the Court of Appeal can interpret the Constitution, and then when you file in the High Court must follow whatever interpretation is given. It means you have to file it in the High Court, and the High Court has to do the interpretation. When you appeal and you come to the full court, the Court of Appeal, the Court of Appeal will have that power too. So it does not remove this right. But you see, the High Court is a court of inherent jurisdiction. The Court of Appeal is a court of statutory jurisdiction. And the CCJ similarly. Appellate courts don't really have the wide ambit that High Court judges do. High Court judges, they can literally make night day. I mean, not if you understand what I mean. Court of Appeal judges are bound by the Court of Appeal Act and the rules. There is something in the High Court called an inherent jurisdiction, and the procedures are wider.
Right.
But for the purposes of what is going on here, You, for example, when we dealt with Article 163, and everybody knows that it says the High Court shall have exclusive jurisdiction to hear any issues out of the election, and you got to pay. That article also said that the Parliament must make laws for you how to enforce it, and Parliament did. They passed the National Assembly Validity of Elections Act, and in that act they put regulations to put specifically how to enforce it.
Right.
So that one has been totally fleshed out, and the statutory regime is present. There is, I'm going into a little bit that might be a little bit more technical and detailed, but I think what has happened in Guyana is everybody is clued in now, and everybody's interested.
The smart, they're getting smarter.
Good for you to understand. It would be good for your viewers and your listeners to understand why it is that those of us who are appearing other than for APNU or other than in the coalition's agenda have been saying repeatedly that these proceedings are utterly without merit. They will achieve nothing towards injuncting or preventing or stopping anybody from doing. There is right now no stop on GCOM to go do the declaration. There is no order granted, and none can be under these proceedings. Maybe what we will see is more proceedings come again. Maybe that's all.
Spend a minute there, please. If the chairman of GCOM is saying that, look, the court should withdraw, this thing should be thrown out because of all that she has pointed out, there is no injunction in place. What is restraining GCOM then?
Good question.
There is no legal impediment. I can tell you that. What is stopping GCOM from actually doing anything or going ahead? It might be just the caution of the chairwoman. She might just say, well, there are legal proceedings. Let us hear what the court said. But
in this case, it is that Lowenfield has not presented the report as yet. I mean, let me just pause 1 minute, counsel. Ladies and gentlemen, I want you to remember that what was it, Leonard? March 7th, thereabouts. Sanjeev, you would know these days. Ladies and gentlemen, there was a time in these past 100 days that they were looking for Lowenfield. They were looking to search. They were searching for this man. They were searching for Mingo, and they were not to be found anywhere. And yesterday, in fact, Mingo just heard hearsay that a motion will be filed in court, and he refused to give his report to GCOM. Lowenfield, sorry. Yeah. Lowenfield refused to give his report to GCOM.
What is wrong with that?
The
man is a law-abiding citizen. He wants to err on the side of caution.
He was not stopped or debarred. Sanjeev, over to you. You explain to this gentleman here what.
You see, what is the thing is this. If you are a public officer, there are two sides. You should not act in contempt of court, but you should do your job. Now, in the situation that he was directed by the commission to do something. And unless there was a court order to prevent him from doing so, he should have fulfilled his task. Because this position that we have, that if they are court proceedings, you should do nothing, really extend to different circumstances, not circumstances like this. Because, for example, if he had done his declaration, the case that has been filed, which is for an interpretation of the Constitution, would not be defeated, because the interpretation of the Constitution cannot restrain him. Right. While it is being interpreted, they can't issue interim orders to restrain him to wait for their interpretation, because their interpretation has no relevance to what he's doing. He must do his job. He cannot say that he wants that interpretation and then take that interpretation and apply it. That cannot be the situation. Now, if on the other hand, Leonard, I was going to get an injunction to stop you from breaking down the front door of Kaichur News, and you heard that you thought that you had the right to break down the front door, and you heard that legal proceedings were being filed to stop you to do so. You might, out of prudence, despite the fact that there is no order to stop you, to say, you know what, I know I right to break this front door. And you want carried to court, let me go to court and get the blessing of the court and not jump the gun and do it. Although you can legally do it. It would be prudent of you to not do it. In those circumstances, that court can issue the coercive orders to say to you, don't do it. But in the situation of Lowenfield, the application that is before the Court of Appeal is to tell them Mayor Robertson is alleging that he does not know what the words most votes cast mean in the Constitution, and he would like to engage our judicial system and our judges to help him. So what they're going to tell him is this. Why is it Lowenfield doesn't do his job? Because Lowenfield doesn't need to find the definition of most votes cast. He came up with what he thought it was, and the commission said, listen, Mr. Lowenfield, thanks, but no thanks. I need you to prepare it based on the data of the recount.
Right.
So the commission has done. Now, if you're not happy with that, Lowenfield, or if whoever is not happy with the direction of the commission, you have an election petition. But again, we get back to why they don't want an election petition or to wait for it.
Right.
And principal reason, I believe, is they cannot succeed on an election petition. It is obvious they have no evidence of migrant voters or dead voters. That is obvious. The second reason they might not want to have, however, is because when the PPP's presidential candidate, Irvan Ali, is sworn in, they go out. And they don't want to go out for any reason. Because then they are feeling that they would have lost power. But the reality is they have lost power. The vote has demonstrated that. The PPP, on the fifth day of March, 3 days after the election, the Thursday after the election, took the decision, the leadership took the decision, look, Mingo is messing around and coming up with fantasy numbers for Region 4, let's go.
Right.
And they did. They published all of it. And they said to everybody, this is it. So the whole world knew from the 5th what the PPP was saying.
Correct.
Now, I have said before that APNU has said that they will keep theirs for strategic if they have to go to court. I guarantee you're never going to see it.
But on that point,
Nobody can go to court to be declared a loser of an election. Nobody.
correct. On that point, though, let me just interject, Leonard, and address some of the concerns of some of our viewers and listeners. I want to address a concern expressed by one of our viewers. Ladies and gentlemen, I have seen that there is an article in the Washington Examiner asking for Guyana's sovereignty to be respected and calling on Sarah Ann Lynch and all other persons to stop commentating on Guyana. I want to remind you, don't read the headline for that article. Go down, look at the bottom, and you will see the article was written, and it says so at the bottom, by JJ and B LLC. You remember who's JJ and B LLC? It is the lobbying firm that has been contracted to by APNU AFC for 96 million Guyana dollars. So this is money.
Yog, I saw that article just briefly. The Washington Examiner. I was trying to find them. I was trying to find it and find other things. I mean, of paper. I wasn't able to do so. Admittedly, I've just been doing that between court and coming on today, so I didn't have much time.
Correct.
But I did notice that it was quite strange about the name of the person who allegedly wrote it and what they actually said.
That's right.
But that
but it
is
clear.
if ever there was a propaganda piece That might have been, and I think in this entire election cycle, Leonard and I have had discussions just among ourselves about the number of propaganda stories that are being, put out into the public domain. But Leonard, I think you have to agree with me. That story in these last 100+ days is by far the best propaganda piece. It is entirely fiction.
Yes. But you know, Sanjeev,
Entirely fiction.
the odd thing is that every day we would have heard APNU AFC's narrative creators say Mercury, but when they shared this article, they didn't say that this one is from their own. So, ladies and gentlemen, I just want to take a minute to express and explain this to Mrs. Sanjeev Datadin a minute and a half ago said something very important. And I want to appeal to my sister, Alison Richards. You are a viewer and you have asked a question. And your question is that fraud is fraud, and why should the fraudulent votes be counted? And to you, my sister, Alison Richards, I want to say to you, let us take it to the courts. Let us go with an election petition. I will go with you. And let the courts prove to the courts there was fraud. And if the courts say that there was fraud, I will back that that this election must be nullified and another election must be called. But let us go and allow the courts, Granger or whoever it is or whoever they want to be, cannot want to become GCOM, cannot want to become the courts, and cannot want to continue to thwart the will of these electorates. And the second thing I want to mention, Leonard, I am seeing all of these things hit us every day. Oh, some $150,000 paid to this person and $100 and $200 and something $1,000 paid to that person. Ladies and gentlemen, this country, this last government has boasted about all the work they did for anti-money laundering. Let me tell you something. You take $150,000 Guyana dollars to the bank and see if they're going to accept it without challenging you to tell them where you got it from. So don't be fooled by the narratives of this money. Listen, it is APNU AFC that has a commissioner of police in there. And I'm not saying that that is political, but they have the wherewithal. The president is the commander-in-chief. There is a minister of public security. So don't let the minister of any one of them come out and say about this money and that money. They have the wherewithal to put the facts out in public rather than create false narratives to drive people nuts in this country. Don't drink that Kool-Aid. If you want to drink a Kool-Aid, drink the Kool-Aid of the following. The song that Mr. Granger sang in 2015, that song brought tears to the eyes of many people when he sang, "Can we do it? Yes, we can." And 5 years later, Mr. Granger's translated, "Can he do it? Yes, he can," meaning he and his little cabal alone, not the people of Guyana. So I'm appealing to you, don't do like what Orrin Gordon said. Orrin Gordon came here 2 weeks in this program and he said, I will use my own brain and the education that Burnham afforded me, and I will speak the truth. And the truth was that the APNU AFC lost these elections and need to get out. They're squatting in power. So don't fall for these false narratives of this money and that money and everything. We got to put it to bed. They can't be boasting of implementing strong anti-money laundering and then say there was money laundering. But we know where the corruption is. We are seeing it in front of our eyes. We are seeing today how much trucks, 6 trucks or 8 trucks being bought for $600 million by GPL. And I want to ask council to comment on that, whether a board that is not renewed can spend such money. But before that, council, I just want to say, Cathy George has asked a very important question, but Cathy, I believe council would have answered that the chairman could have, Cathy is asking council whether the chairman can declare with or without quorum. and whether she needs to call a meeting as early as possible, notwithstanding the court case, especially now that she has said they should throw this court case out.
She can declare with a quorum on the first day that the meeting is called. So if she calls the meeting tomorrow and there is a quorum, then the declaration can be made. If on the first meeting there is no quorum, the second meeting has to be had same time, same place, the following day, 24 hours later. Mm-hmm. And even if there is not a quorum, she can, at that stage, she can declare it. Okay. So the first meeting requires a quorum, the second one does not.
Great.
Because otherwise, if you had to have a quorum, one side could just choose to stay away perpetually. Mm-hmm. And thwart the will. But these things that are going on, you know, I was saying that it is really unfortunate. It is really unfortunate that what is going on is people are saying that you should be allowed to ventilate your rights. And this filing of the interpretation they claim is it. But let's be honest. The first thing we were told that we should be allowed to ventilate rights on is that 32 is not a majority of 65. Mm-hmm. And every child who is 4 years old or 5 years old and can count knows that that's a fact. But they said that they will remain in power while they go to verify this ridiculous proposition. It was followed by then the fiasco of getting a chairman for GCOM. They unilaterally appointed a chairman. Then when it came to the appointment, they say, well, that means their interpretation is they could put names on the list. Where in God's name would that make sense, man?
Right. Correct.
Leonard and I have to decide. Leonard has to give me 6 names for me to pick who will be the radio presenter. And Leonard has to take the names I say to put on the list. Who the hell do you think I will pick? I will tell Leonard, well, here what? You have to put these 2 people on your list. Leonard put the people, I pick them. I mean, it might as well be that Leonard doesn't have a right to pick.
Correct.
And that perversion permeated every single thing from the no confidence motion.
Yes.
First, it was they lost. On the night, they said they lost. They got to hold the election. Then the lie came. Engineered by the former chairman of the AFC, engineered by somebody who had an interest in a most dastardly lie, and put the entire nation that we have to wait while this process goes through. How could that make sense, man? How could that? Is it everything that you want to go to the court for while you sit in power? So you will want to decide whether Wednesday comes after Tuesday, and you will say, no, it doesn't, and then we have to go to court to decide that. This is how stupid it is. Then when that happened, then the court said you're on a different footing. You are a caretaker government. As far as they were concerned, they were not. They functioned. People were powerless to stop it. The institutions that we have were not strong enough to stop it, including the courts. Then we got to the election. Eventually we got to the election. More than a year later than from when it should have been held. A year later. Then we got with all of the nonsense about what Mingo was doing. Then when they had agreed to a recount, the leader, Granger, and Jagdeo, the leaders agreed. Then Yulita Moore came and filed the case. Paying lawyers, senior counsel from all across the Caribbean to appear for Yulita Moore. It's obvious. It's obvious Yulita Moore was a surrogate for the coalition. And then what happened after that? That too was stupid. What was the case that Yulita Moore filed? Yulita Moore filed a case that says we shouldn't have a recount. When everyone agreed to a recount, and it was as plain as day that it's in the Constitution, GCOM had the power to order it. Mm-hmm. So we had to wait while that was going on. Now we have this. You really don't know what the words votes cast mean. You really don't know? I could ask a little child to explain it.
Yeah,
Exactly. These things are so obvious. But then we say, well, we have to wait while the court decides it. These things are an abuse of power to the highest order. And quite possibly we're not done with litigation. Quite possibly we're not done. Quite possibly they're going to invent more things to do. But these things are all nonsensical.
So
they are without merit, and they really get people whipped into a frenzy. Is the court going to do this? Is the judge going to do this? Is this going to happen? You breed uncertainty. You breed distrust. And what you do is you break the fabric of your society.
Correct.
Because what you do is you feed the hate.
Correct.
You feed this hate because the only way for you to have an explanation for your defeat is that the other side cheated you.
Mm-hmm.
And if the other side cheated you, that means all of their supporters are dishonorable people because they are part of the conspiracy to cheat. But that wasn't enough this time. The British ambassador was part of the cheat. The American ambassador, the Canadian High Commissioner, the European
I think you were part
ambassador,
of the cheat too.
Yeah, yes. Sanjeev,
everybody was part of the cheat. They said I was part of the cheat. Two of you were part of the cheat.
I was.
They say everybody.
But you notice he said you, Leonard. I stand clean and clear.
No, but I want to ask you. I want to ask you, Counsel, here very quickly.
But Leonard, it went on about Mercury did all of this. Now I am telling you this. If Mercury has this capacity that they allege, if the PPP have these powers to send people out of Guyana and let them walk back along the Central American, Pan American highway and come back to Guyana and vote secretly and go away, or send people who look exactly like them all across the country to vote, then really they should win the election, man.
Mm-hmm.
They have exceptional skills.
Yeah, you have done all of this. Yeah, and you know what else? It seems like PPP, now they're spreading news. PPP paid Mingo and PPP paid everybody. So PPP paid everybody for APNU AFC to win. But Council, I want to ask you a hypothetical question. Now, on one hand, you have Madam Chairman's request of the court today to throw the case out. On the other hand, you have all the arguments you have presented here. And on the other side, you have all of this that has happened, right? That the case is from the appellant side. Now, middle down the center, you also have CARICOM Observer Team's report. Now, the question, hypothetically, if the courts were to pursue this matter, listen to this matter, and make a decision for the appellant, where does it leave Justice Claudette Singh given her statement now?
Well, if they were to pursue the case and they are to rule for the appellant, it doesn't give the appellant a coercive order. It will give the appellant, listen, madam, what these words mean is as follows.
Okay.
That's it.
Mm-hmm.
You know, that's really it.
Understood. So not necessarily an injunction.
This is why I was explaining earlier when I said to Leonard that this is not the kind of matter where Lowenfield should stop, because there is no possibility or risk of him, what he is doing, to be directed in any way.
Mm-hmm.
What this is an interpretation only of the Constitution. You can't make it into what it's not, because you have to realize this. When a specific special power like this is given in a court, it has to be very, very strictly interpreted. Because this really takes it out of the norm. Why not go to the High Court for the declarations? Why not go to the High Court to find out what the meaning is? This is a very specific thing. And for that, it has to be very narrowly construed. because the whole principle of law is, and I believe we dealt with it in the previous cases about restrictive anismenic, which says basically that if you are to oust the jurisdiction of a court, of the High Court, the court will interpret that as narrowly as possible, because what the principle of law is, you should never oust the jurisdiction of the court unless you specifically do so. So this provision is seeking to do is oust the jurisdiction of the High Court.
That's right.
Which I know in the hierarchy it might not be the highest, but the High Court is the most powerful court we have because of its powers, its inherent powers, including its statutory powers.
Correct.
So the High Court always is the place where much more can be done.
That's right.
And that to oust the jurisdiction of that, it will be very narrowly construed. And in my humble opinion, not to be arguing out of court, but in my humble opinion, the fact that the legislative mechanism has not been put in place, I'm not sure that there's a way to approach the court. And secondly, it really relates to the court's jurisdiction is engaged after the person has been elected president.
Correct. So I have another hypothetical scenario for you, and let me just say, my dear sister Alison, I call your name because your brother Yog loves you, and I pray for you every day. So I must explain to you too. But Sanjeev, here is another hypothetical. You opined earlier that they are scared of taking of the elections petition because they don't have a case. Supposing, let us just say that they do, or let us say they approach the courts with an elections petition, and on some technicality, like what happened with the Esther Pereira case, on some technicality, it is so ruled. That's one. What happens there? And two, suppose they take an elections petition to the court, and the court says you don't have a case. What then would be borne out for all the pains and frustrations caused to the Guyanese people?
Well, I tell you what, in the first instance that you made, the ruling in Esther Pereira where a difficulty was found, it was to vitiate the elections. But that was a specific, unique thing. I mean, it's the only case that part has been taken about vitiating the elections. But strictly speaking, what would happen in a petition is your burden that you have to demonstrate is that all the proven facts that you have put before the court would mean that the result that has been declared by the GCOM is incorrect. So what you will have to do is you will have to show that what APNU will have to do is to show that they would have won the election. Showing that there is a discrepancy, let us say, for argument's sake, that I know that the complaint letters which Kaichur News published two sets of letters where they were saying they were migrant and the police commissioner should investigate. The first one was sent. The second one, I don't think was sent. I think the total number on that is 460 odd, 64, 63, somewhere around there, 400 odd. And the complaint related to these specific people. Now, the thing would be, if you were to file a petition and you're questioning these 400 odd specific people, even if you were to prove that that was exactly so and you are right, then you are 15,416 votes behind. So you probably would only clear off the 400 votes. What are you going to say is difference with the result in the 15,000 votes? Now, how are you making that up? And so that would be the challenge. The burden of proof is you have to show that the result would have been different. And the reason for that is, that the English legal system and the legal system recognizes that when you have 460,000 odd persons voting, there are going to be discrepancies here and there of things that might not match 100% on all fours exactly. So you have to look at the scale of things to see whether on the scale of which it happened, it was systemic and this is what happened. Now, the CARICOM report has the correct approach. The CARICOM said, despite all the discrepancies, which they considered to be minor discrepancies, there's nothing to stop the declaration. Firstly, they said that the elections were representative of the will of the people, and there is nothing that should stop the declaration, even if there were these few things, because it is within the normal realm that you would have a few things here and there. Now, what APNU and their leaders have been doing is saying these things over and over, but they're not telling the people that the maximum number of thing is not even 400, not even 400 discrepancies. Poll books are not relevant because poll books are really a record that the presiding officer keeps. That has nothing to do with who votes. Ticking off that list is not a strict statutory requirement. Putting all the ballots in one envelope versus the next envelope those might be statutory requirements, but realistically, you will invalidate a man's vote because the GCOM person put it in the wrong envelope. These things, when you think about it, you can't disenfranchise people in that way.
Correct.
The law wasn't meant to do that. And it is correct. There's an Eastern Caribbean decision that says elections shouldn't be about technicalities. Elections must be representative of the will of the people. And there will be a winner and there will be a loser. But we can't get carried away on technicalities only to thwart the will of the people. How could that be? This country, our country, Yog, is not a very rich country. We might be one day. We hopefully will be. We're a very poor country. We have people who struggle daily to make their living, to feed their children, to put their children in school. And we spent more than $8 billion to do an election.
Yep.
And we have two people. Mingo decided to invent numbers. Lowenfield has a unique way of counting. Two persons want to say that we should do this over. Where are we going to find the money to do it?
Correct.
We are a poor country. Do you know what we could have done with the $8 billion that was put into this?
Correct.
Most countries don't spend that size of their budget on an election.
Right.
We spent more on the election. And I stand to be corrected because I looked at the budgets that were passed the last time in 2018 when the Parliament sat. And if my reading is correct, we spent more on the election than we spent on education in the whole nation. Now, if that's not a travesty,
right? That's
what is.
Yeah. So, Council, I have we are running down to program time, and I have one more question for you. But just before I give you that question, ladies and gentlemen, I want to remind you that during this program, we have made some announcements. One was that the Justice for All Party, a member of the coalition, has conceded that the PPPC has won these elections and has demanded that the delay must stop now and the PPPC must be declared and President and Irfan Ali sworn in as president. So that's one. Two, we have also announced that the Center for Interreligious Dialogue of Guyana has called on Granger to concede. Three, I am informed, and thanks to Pandit Ravi, that the Virat Sabha has also demanded that Granger concedes. We have also, and you would have seen on top the ticker tape going, we have also announced that we have reports and we're continuing to investigate that Mr. Ramjatan would have told his staff that they have lost these elections and stuff like that. And you will see something in Kaito News tomorrow. We have also in today's Kaiser News shared with the public that we have been made to understand that Walter Lawrence would have packed up and basically moved out of her office. We have also seen in Kaiser News today that Granger himself would have packed up his stuff from the office of the president. And so we have seen one after the other. The chips are coming off. And so you are seeing now in these last days the core of those who are intent on holding this country at ransom. I would like to make a call. Mr. Granger, 5 years ago, you stood up as a person representing the hope of a country. Sir, you can choose, you could have chosen to go out in glory, but it seems like you have chosen to go out in shame. Shame on you, sir, if even at this last moment you cannot accept that you have been defeated at the polls, and let Guyana breathe. Sir, let Guyana breathe. Go enjoy your pension. Mr. Sanjeev, Datadin Council.
I am just seeing, well, my wife is just telling me actually while you were speaking that Newsroom is running a story that Comrade Ramstan has said. What we were saying earlier.
Yeah, it is based on the same inside feed that we have received from staff therein. Council, my question to you is that I want to come to a man that you have, well, not a man, I want to come to somebody. You have had a better name for this person than I'm going to say. Mr. Basil Williams has written an op-ed in the Guyana Chronicle where he has used cases that were after a declaration to argue a case that you should have the court's intervention before declaration. I found that really maddening. But this is the same gentleman that is going to go to the courts tomorrow and take APNU AFC side. Is there a conflict of interest, sir?
Well, I guess he's been put there by the APNU, by the party. He's the Attorney General as their representative. He should, of course, be the Attorney General above all if he's going to act there in that post. But one of the things that was interesting about the op-ed, because we're in the middle of whenever these cases come up, as has been the history since the no confidence motion, the courts have been giving us very, very tight timelines, very difficult timelines to get work done. And I didn't get to read very much of what Mr. Williams wrote about these things. One thing was an absolute glaring thing that I noticed about it. In addition to, as you saying, that it was matters where it had all come after, is those were cases where what all of the litigants wanted to do was to establish a pattern of fraud or to establish a pattern of wrongdoing, and basically to allege electoral fraud. What they were forced to do, and what any person in their position would have to do, is when you approach the court, you have to produce your evidence. And when you produce your evidence, you have to, on a balance of probabilities, you have to show that you're telling the truth. The challenge that we have right now in Guyana is this. There has been no evidence produced to support or substantiate any of the claims. Now, as the CARICOM report correctly said, this was in fact an audit and not a recount. If it was a recount, it should have been done faster. It should have been easier, and you need not have checked what you did. But you need not have checked what you did because APNU wanted to delay the process. But they have essentially solved their own dilemma. And what Mr. Williams is trying to raise about what was ruled in these cases could not be the situation now, simply because the audited reports and the audited recount is really where what the court would have ordered to resolve the problem of the count. And this is already done. Now, if he wants to take an issue about what votes are valid and what votes are not valid, he cannot go beyond the ballot. Not even the court, whenever it would come to consider, the court can't go beyond the ballot. Because let us take, for practical purposes, that you have these ballots, which are valid ballots, they have the security features, they're not spoiled, all of this. And you're saying that only the ballots were in the ballot box. Well, guess what? The law says that's all that really should be there.
Yes.
All that you have to find are the ballots. Now, if you want to go around in a circle to say that these were not, you see, what happened in Guyana, I was speaking to a gentleman that he was formerly a prime minister, and he is a good friend of mine, and we speak from time to time. And he said, you know, one of the things that happened in Guyana was this. Born out of the 1980s, where the rage was so much that elections were being rigged in front of people's eyes and they could not do anything, that the list of things that were built up over the time as to what we need for security and what we need to prove that so that they can't cheat us, that was the mentality. I mean, on another program, hopefully, one time, I'll tell you a story about my grandfather that I hope history don't repeat itself here. I believe Yog knows the story from other sources, but about my involved my grandfather in ballot boxes. Mm-hmm. But the reality is this: we knew immediately what were the things we wanted. We wanted secure polling places. We wanted counting at place of poll, because the army would take the ballot boxes and stuff the boxes and come back. And there were all these things that were happening in the 80s documented. Mm-hmm. Then we wanted to have security features, specific tape to put on the box. The tape must have the lid. There were all these things that developed over the years, all because we suffered for 2 decades with rigged elections. All the 70s, all the 80s. Right. So we knew inherently what we wanted to get done, and we did. And as a result of that, what we currently have in Guyana might lead the world in terms of how many checks, balances, and security features we have, which is why it costs us so much.
Correct.
The ballot papers and the statement of polls that are issued to people are printed on paper that money is printed on. The security features are like money, and it is money, which is very expensive paper. That's why we spent $8 billion on it. And then, in addition to that, the folios with the pictures, the voters list, the OLE in every box, the recording of this, the recording of that, the check and the balance, the scrutineers must sign. It must be posted outside, on the wall, on the door, so that people could see it. We have probably implemented all of the checks and balances known to mankind. That's right. Where it comes to these things.
Thank you.
And that is why it is nearly impossible for what they have alleged happened with dead and migrant voters. Because that would mean, essentially, Yog, this is what they would say is happening. That person A would go and vote at station A. Then he would go, change his clothes, change his physical appearance, put on a face, and get the ID card too for the person whose face he's just put on. And he goes and he votes at place B. Then he goes away again. He gets face number 3, an ID card to match face number 3. And he goes there, and then he's matching the folio pictures as the same. This is impossible to do. Think about it. Even if you were making a movie, Yog, you couldn't do that. You just couldn't do that. You couldn't make it up.
Thank you.
But
You're right.
what they would like to keep fooling and saying to people about these possibilities.
Mm-hmm.
Now, really and truly, these proceedings and what they're saying in these proceedings about an interpretation of the Constitution adds nothing to the question, adds nothing to the equations that we have to consider, which is the declaration, the numbers. There could be no coercive orders issued. The court has no power. I have a personal view, and I don't want it to be taken as anything. I have a personal view that the court has no jurisdiction because they are prerequisites. There should have been a statutory regime on one issue, and the second ground is I don't believe that the section applies even if they want to use it because it speaks of the person having been elected. So there are those challenges that, and I don't believe the court has jurisdiction, but we will find out what the court will rule.
Correct.
Soon enough.
Correct. Well, thank you for that. Thank you for that, counsel. And ladies and gentlemen, we are at program time. Let me remind you all, we owe a debt of gratitude to persons like Mr. Sanjeev Datadin for coming on Room 592 and making sure that we understand all of these technicalities and putting us in the right perspective. Let me also remind you, and let me make a call, Mr. Basil Williams, a year ago or something like that, you made a statement that the former government you accused the former government of making Guyana into pariah state. Sir, you and your team has made us into a pariah state. Today, Guyana is being disrespected and being threatened by all the countries in the world. You have lost. Mr. Granger and team, you have lost these elections. Time is up. Stop squatting on state property. Ladies and gentlemen, Mr. Datadin, thank you so much for joining us.
Thank you, thank you, Leonard.
Thank you very much. I have a quick question, if I may have the good counsel, a quick question. Could you say if we could see, if tomorrow is that case, could we see decision as early as Sunday?
I would think so. My personal view, given the history of how the timelines are going, I think tomorrow arguments are, if everybody's restricted to half an hour, there might only be 3 persons that would actually use that half an hour. Mm-hmm. So it might go for about that long, about an hour and a half, 2 hours. I would then think that maybe Sunday, but no later than Monday, I would say there'd be a ruling.
Thank you.
Thank you.
Thank you. And ladies and gentlemen,
I want you to take, that's my guess.
Yes, we got that. I was actually going to add that to my final comment that, ladies and gentlemen, please know that we are thankful for Mr. Sanjeev Datadin to give us his opinion here tonight. But as he has said, it's his opinion, and we can only look at it from where we are sitting now. It's in hands of the learned judges, the esteemed judges at the court tomorrow to take us through that challenge. From where we sit, here is tonight's program has been how we see it. And so, ladies and gentlemen, on your behalf, I thank Mr. Datadin once again. And on your behalf, let me also thank Kevin Smith and Joshua Van Slightman and the entire Kaito Radio team for doing a wonderful job in making sure this program is a possibility. And of course, Mr. Glenn Lal for putting his heart on his sleeve and ensuring these programs are free for you and I to learn from. It's been a pleasure. It's been
good night to you. Good night, Leonard. Good night to your listeners.
Good night to you.
May your God be with you.
Thank you. And ladies and gentlemen, it's been a pleasure to have you once again in room 592. Be safe wherever you are. And please remember, say a prayer for this wonderful country of ours. God bless you. And from Kaito Radio, from room 592, we love you. Have a great night, everyone.
Thank you.
All right, good night.
Good night.